As serious of a crime as criminal threats is, and really it's something that can be a strike under California three strikes law and put you in custody for several years, the fact is a lot of innocent people do get charged with this offense, and it can be a very difficult crime for the prosecutor to prove. As defense lawyers, we really look at three primary strategies in a criminal threats case when we're defending someone charged with a crime. The first is to challenge whether the prosecutor can even prove that the threat was made. So it may have been something that you said verbally, and there's no witnesses, there's no corroboration, there's just the testimony of the alleged victim. That can be very unconvincing evidence in court. Even if there was a threat made by, let's say, a text message or an email, it may be difficult for the prosecutor to authenticate that electronic means in court. So it may not come into evidence, and the prosecutor may not be able to prove that a threat was ever made to begin with. The second strategy is to show that you were not serious about the threat. And that is to say that maybe you were just kidding, you were blowing off some hot air, you were speaking in jest, but you really did not intend for that threat to be taken seriously, or you did not intend to put the person in fear. And if that's the case, then the crime of criminal threats did not take place. The third defense strategy is to show that the alleged victim was not actually placed in fear. So for the crime to be committed, for the prosecutor to prove the crime in court, they have to show that the person who was threatened really was in genuine fear for a period of time. And that may not have been the case. They may not have taken the threat seriously. I had a case where a client was accused of basically telling the alleged victim, "I'm going to kill you." And we had evidence that the alleged victim's response was, "F you, I'm going to kill you first." And really, we were able to show, look, this is not the behavior of somebody who takes a threat seriously and is in fear. And our client was exonerated. So between these three strategies, one, challenging whether the threat ever took place, two, showing that you weren't seriously trying to put the person in fear, or three, showing that the person wasn't really in fear, we've had a great deal of success. We invite you to contact us here at Schaus Law Group. Let us investigate the case. It may well be possible to get the charges reduced or even dismissed.